payment. Is that right? If you know?
I believe that it is, if it's for the payment that he received in 2017, yes. He
Okay.
received a payment in 2017 for $30,000. Wasn't entitled to it. It wasn't the end of his 4-year term.
Right. But I'm thinking about, I have before me the payment, an allegation that the city council approved it, and this one at least has his name, and then an allegation of concealment later. And I'm trying to reconcile all the information that I have in front of me here at this um, stage, which is the motion to dismiss stage, which I recognize is very favorable to the petitioner. And so anyway, I'm just trying to figure out how I reconcile this document that does have his name and it says $30,000. Um,
So I'm not saying that he concealed the 2017 payment.
okay,
I'm saying he's not entitled to it. Under the reading of the ordinance, it's completion of a full term. He had not completed a full term as of 2017. His 4-year term began in 2014. He
okay,
completed it in 2018. And then it was after that he began to conceal the payments.
okay.
And, and then he
Go ahead.
and then he wasn't entitled to annual payments.
Um, okay. Am I the respondent has taken the position, and I want to know what your position is at this stage, can I take judicial notice of the other longevity ordinance and these budget documents that each side has referenced? But I think you're at least in your papers, I think your position at least sounds to me is a little bit different. What is your position as to what, if anything, I can do with the other longevity ordinance and these budget documents?
I mean, you can take judicial notice of them if you like. You're not required to.
Hmm.
I wasn't going to waive the our argument that these items were outside of the four corners of the order to show cause and should not be considered. But I
Sure,
also was going to address them, since they were there.
sure, I
The
get it.
the what's interesting about the other longevity ordinance is it says annually. And so the city is presumed to know that that language exists if they wanted to impose it on the mayor's longevity ordinance, but they did. What they said is at the full term, the full completed term, which is 4 years.
I think I understand
I
that. Okay.
so I'll stop there. I just want to say that taking the facts as alleged by the petitioner as true, drawing all reasonable inferences in the petitioner's favor, and where the order show cause suggests petitioner is entitled to the relief requested, the presiding officer should deny respondent DiMaria's motion to dismiss.
Can I ask a statute of limitations? I think I may have cut you off when you may have been thinking about it. I reckon it seems like the payments occur over time, and the payments I'm thinking about is count one, and then the concealment is count two. Um, is the look back? I recognize that there's pursuant to the regulations, continuing. There's a look back when the continuing conduct is discovered within the statute of limitations and that's set forth in the regulations. Does that apply equally to each count?
So the continuing, yes, and the continuing violation is the misconstruction of the ordinance from 2017 through the last payment that he received in 2021. He misconstrued the ordinance from the very beginning, from that 2017 payment that he received in for $100,000 right through the payments he received in April of 2021, excuse me.
Okay.
That's his continuing.
Okay. And I if the respondent has any very brief response to enforcement, I'll hear it. Otherwise, I have some sort of concluding remarks.
Just briefly.
Okay.
Commissioner, you have no facts before you right now that you won't have in an identical sense at a summary judgment phase. You have the local mayor's ordinance. You have 268A in the alleged violations there, and you have a city council vote, and you have Mass General Law, Chapter 44, Section 32. Okay, and I want to thank Candace for acknowledging that you can take judicial notice of all those factors today. And the reason we filed the motion to dismiss based on the law is exactly to save us from this process going forward. Because apart from the process going forward, it also impacts the kind of evidence that I'll be required to submit. Think about it, Commissioner. If I don't know what the jury instruction is, if I don't know what authorization means, how do I present evidence on that issue down the road? That is an issue of law that you and the commission needs to address and settle now. And again, I appreciate all the factual arguments that enforcement raises, but the reality is a simple one. The city council that enacted this ordinance in 2016 voted on it 10 months later, and again enacted a payment, authorized the payment for a certain amount that is consistent with what Mayor DiMaria accepted, and a frequency in amount that was consistent with what Mayor DiMaria accepted. And that was in 17, 18, and 19. So there's no getting away from that. Those are issues of judicial notice. And then the question becomes, is that authority? Is that the kind of authority that 268A Section 23 envisions? And it absolutely does. It is not up to enforcement to raise issues of fact to determine what authorization is. That is an issue of law for you and the commission to consider and address, because it impacts not only the dismissal, which this case should be dismissed, but also my presentation of evidence going forward and Mr. DiMaria's due process rights in putting forward a proper defense for this matter down the road. Again, It should be dismissed. You can't get away from the votes. It was an authorized amount. At the end of the day, there's all kinds of amounts tendered to a city council for authorization of payment. They don't have to accept it. They can take it. They don't have to take it. They can accept it. They can deny it. A common occurrence that happens today, just as a matter of pure argument, is this defund the police argument that you hear, right? Well, you know, a mayor can have a certain amount of money in a budget to fund police. But in the city of Boston, if they defund that line item, doesn't matter that there's an ordinance or a mayoral recommendation that it be paid. It's not authorized because the city council didn't vote for it. And you have the same situation here. For a payment to be authorized or not authorized, ultimately under 44, Section 32 is the purview of the Everett City Council, not enforcement, not the SEC Enforcement Office. Thank you.
Okay. Any response to anything that Mr. D'Ambrosio just said, Attorney Pruitt?
I'll just take it to its absurd result. If the city council had voted for a $10 million payment to Mayor DiMaria for as a longevity payment, the respondent's argument seems to be that that would be okay because the city council voted on it, and that simply could not be the case.
Can I rebut?
I'm interested in what your rebuttal is to that.
Sure, it's the same example that enforcement cited in their brief. There's a 10-person taxpayer lawsuit provided by the statute that allows taxpayers to come back and contest it. There is a well-defined set of cases that defines how that is done. Again, and we if you look at our reply to her motion, we detail the SJC case that's right on point, that provides the law on the issue she just raised. The point is, no, a city council shouldn't be approving a $10 million line item. But once it's voted on, it is authorized. It is authorized. The SJC has already said it is authorized as a matter of law. The recourse is the procedure laid out in the ordinance and in the SJC case that we cite in our brief.
Well,
It
okay.
is not up to enforcement to determine that. That is the
Well,
point here.
I mean, there can be more than one remedy for wrongdoing, and but I hear your point that you're pointing me to another one, and I'll have to think about it. So, the next step here
But let
is
me ask, Commissioner, my point is, there can
Yeah.
be, if a person of common intelligence sees that a city council interprets it a certain way and votes on it a certain way and authorizes it a certain way, right? How at the end of the day, let's get away from a $10 million exception. How does a city council interpreting an annual payment consistent with its past ordinance somehow give rise to an independent liability for something like this? That's exactly why it's overly vague. And again, ethics violations should not be attached. They should not be affixed to ordinances that are ambiguous like this one is.
right. I mean, that's predicated on it being ambiguous, and I'm not there yet. And but here's what I have to do. Um, So, in order to, there's interesting legal and factual issues raised throughout this. The way that I have to think about this, and I'm going to reread everything. I'm going to listen to this hearing again. I anticipate because I took notes, I think what both sides said were insightful, and so I want to make sure that I can slow them down and play them again. And then I ultimately have to decide whether I think that this is a matter that should be brought to the full commission or it's a matter that I can resolve. But just so it's clear, I can only resolve this by denying it. But if I conclude that it's something that should be brought to the full commission, it doesn't necessarily mean I've decided how I'm going to vote, other than that I feel that I shouldn't deny it myself. Um, but those are the next steps. I'm not sure exactly on the timing of what I'm going to do, but I plan to work as promptly as possible. I know that this is an important matter for everyone I see on the screen, and I imagine for others I don't see on the screen who have worked on this case, and for people in Everett and for Mr. DiMaria's family. I recognize that, so I'll work quickly, but I don't want to work so quickly that I make a rash decision. But that's what happens next. And so I just wanted to make sure that everyone understands it. And ultimately, you'll hear from on whatever the next steps are from Attorney Breslin. Okay. Any questions about the process?
Would there be arguments, Commissioner Hanley, before the commission on this, or would it be an internal deliberation?
If I think of me as a gatekeeper at that stage, and if I, as a gatekeeper, present it to the full commission, I anticipate that the full commission would be interested in argument. But we're not there yet.
Very good.
Okay. Any other questions? I appreciate everybody's time, the preparation of the argument, and the legal issues that were raised. You've given me plenty of work to do, so thank you.
Thank you.
Thank you.
Thank you. Take care.